Good afternoon, everyone. My name is Danielle Whittingham, Chief Operating Officer for the Madison County Economic Development Authority. Welcome to the HR Roundtable meeting. Your microphones are muted, but the chat function is available in case you would like to use it. Questions and comments shared in the chat will be reviewed and directed to the appropriate person after the meeting. We are recording this webinar. The recording, along with answers to your questions, will be posted to our website at madisoncountyeda.com. Each quarter, MCEDA invites HR directors, plant managers, and workforce partners from Madison County businesses and industries together to network, share best practices, provide resources, and collaborate to address industry needs. During our previous meeting, Jackie Turner, Executive Director for the Mississippi Department of Employment Security, and her team spoke about what employers needed to know about the unemployment process and benefits during the COVID-19 pandemic. Timothy Rush, Reemployment Assistance Director for MDES, and Jimmy Giles, Workforce Coordinator for CMPDD, also answered questions that were sent in by Madison County businesses. Jackie and her team have graciously agreed to speak to our group again this quarter to provide an update now that businesses are reopening and asking their employees to come back to work. Like the previous meeting, Jimmy Giles and Timothy Rush will collaborate to answer questions that participants submitted ahead of the webinar. Without further delay, let's welcome Jackie Turner and her team. Thank you so much for joining us, Jackie.
Thank you for having us today. I'm Jackie Turner. I'm the Executive Director of Department of Employment Security, and we appreciate you all being here with us today. Jimmy Giles is going to facilitate this session, and Mr. Timothy Rush, the Director of Unemployment Insurance, is going to answer your questions. When you leave here today, please know that you can go to our website at any time and get information on fraud, Restart Mississippi, the governor's executive order, which we think will be some parts of it extended in the next couple of days. So please watch out for those things, and always know that you can reach out to us. One of our priorities is to be responsive to your needs. You are the employers of Madison County, and we need your help in combating fraud and getting people back to work, and all of those things that need to happen as we open the economy back up. So I'm going to turn it over to Mr. Giles and Mr. Rush. Thank you for allowing us to be here today.
Good afternoon. First of all, I want to say thank you for everybody for showing up and for MCEDA for hosting this. My understanding is they're going to try to record the session today and make that available for sharing across the state with employers all across Mississippi. So if I believe they'll put it out on their website. So if you have other coworkers, other businesses you know of that may benefit from this, please direct them to MCEDA's website. As we discussed, Mr. Timothy Rush is here. We received some questions from employers, and I'm going to walk through those questions, and Mr. Rush will provide answers to those. But before I begin, I want to ask Timothy if he has anything he would like to say before we start with the question session.
Thank you, Jimmy, for the opportunity to participate today, and look forward to addressing questions and hopefully responding to your needs. I have questions that I'm thinking about that may not have been asked, and maybe I can infuse those into the process, but just look forward to this dialogue.
All right, thank you, sir. All right, so we're going to begin, and I'm just going to kind of briefly read through these. They are shown on the screen, so I hope everyone can see those. But the first one comes in and states that we have some team members, employees, who accepted return to work, offers of return to work. However, they're calling in for their shifts, stating it's due to personal or other reasons without any documentation provided. We have multiple team members saying they have no child care, but they're not even looking for alternatives. All of these team members are filing for partial unemployment, even though we have work available. They're coming up with a variety of reasons not to come in and work their full schedules, even though they have accepted the offer of work. So the question is this basically a refusal of work based on their original return to work offer? How do we handle these situations? We are especially concerned about those claiming child care issues. We are not subject to the family's first paid leave because we have over 500 team members and a time off policy available, and we don't want to run afoul of any legal issues. So Mr. Rush, can you address this one?
Sure. First, regarding whether or not this is a refusal of work, certainly it sounds like it is a refusal of work. The employers should follow their policy regarding notifying the workers that there is work available for them. And if there is work available for them and they refuse to work, then they should notify MDES of that. If those individuals are filing for unemployment benefits, they are subject to a disqualification. If it is a situation where the employee doesn't return back to work, then it should be treated as a voluntary quit. And if the employer has policies addressing a refusal of work or a voluntary quit, then they should follow their policy. As it relates to child care issues under the CARES Act, there are provisions for individuals being unavailable for work because of child care. As it relates specifically to school, the current provisions under the Child Care Act does not find good cause for refusing work for lack of child care as a result of school as being good cause. When school was in session, that was acceptable. However, now the school is not in session, then it is not an acceptable reason for refusing to report to work. As it relates to the Family First Paid Leave Act, that is something that MDS does not have jurisdiction over. However, I did find that there is a Q&A on the Department of Labor's webpage, and at the risk of me reading this to you, I'll hope to respond with something online, but this particular question is raised there, and it's question number 15 on the Q&A session for the Department of Labor, and that's at dol.gov/agencies/pandemic/FFCRA, and that's question number 15, which addresses this. It also says that if the employer and the worker, if this is the reason, meaning the individual cannot report to work because of a lack of child care, and the child care facility is available, then they should utilize that. If the child care facility is not available, then they must, and they may, should I say, the employer may require of the individual to provide the name of the child, the name of the child care facility, the name of the school or place of care, and provide the time in which the individual provider was not available to provide care for that child, and a statement from the employee that there was no other person that they had available to provide care for that individual, and document that. And the employer will certainly be in their right to require that documentation. And should it come to an appeal or to an investigation with MDES, then the investigators would possibly ask for that information and ask the employer if they requested an information. If the person refused to provide that information, then the investigator very well may shift the burden to the employee to provide that information. And if it's determined that that information was provided to the employer and the employer didn't accept that as good cause, then it may end up with the claim being allowed. But if the employer does require that information and the person does not produce it or present that information, then the employer certainly would have a right to either terminate their employment and or report that as a refusal of work, and Mississippi Department of Employment Security would see it as not good cause for refusing work. And under a disqualification for refusing work, individual is subject to a disqualification up to 12 weeks or 3 months. I think that may have addressed it, Jim.
All right. Let me kind of ask it in another fashion, and I'm not sure on this specific question, Timothy, but if I bring my workers back on a full-time status, should I not just let MDS know that I have rehired the individual, they are back full-time, and therefore, if they call in sick, take a day off, they still should be subject, they are a full-time employee, just like in a non-COVID time.
That is correct. If the employee was hired initially on a full-time basis and they are called back to work, and for whatever reason, maybe the individual is calling in admittedly a day or so saying, I'm not available for work, that individual is considered to be job attached and not eligible for unemployment benefits because they are not unemployed under the unemployment law.
Okay. And they can use the restart system we're going to talk about a little later to tell us they've returned full time. Is that correct?
That is correct.
All right. Good deal. All right. So we'll move to the next scenario in question. Okay. So this individual asks, they have team members who no call, no show in order to continue trying to draw unemployment. This is different than calling because these team members don't even attempt to contact us. Our policy has always been that no call, no show is a voluntary quit. And the question is this applicable during COVID-19 and within our legal right to document this as a voluntary quit?
I won't address the issue of what's legal in terms of their rights, but certainly if that is the employer's policy, a no call, no show is considered a voluntary quit, then it is considered a quit. The policy must be made known to the worker. The policy must be fairly and consistently enforced. The policy must be reasonable. And certainly in this case, the employer has a right to expect an individual to report to work or notify the employer when he or she cannot report to work. So no call, no show certainly could be considered as a voluntary quit, and that the employer should follow that policy and treat it as a voluntary quit. If the person happens to be incapacitated and couldn't call in, I think the employer would deal with it on a one-on-one basis and make a determination as to whether or not they think good cause existed for them not being able to call in.
So again, I'm going to ask a little further question along this line. So it appears here the individual is at least drawing unemployment or has been, returns to work, no call, no show. If they are currently filing for unemployment, we may not be aware, MDS may not be aware that a separation has occurred. What should that employer do to alert MDS that this individual has now separated from employment?
Well, the individual employer should notify MDS, and I think it may be discussed further in the meeting, Jimmy, as it deals with Restart Mississippi. There is currently a way for the employer to notify MDS. The way that we're promoting at this time would be for the employer to log in, go to our MDS website, which would be www.mds.ms.gov, and there on that homepage to identify for the employer to report that a person has been separated, a person has refused work, or cannot be located with Restart MS or Restart Mississippi. So they could notify us of that, as in some cases we do not know whether or not the person has been called back to work or there's work available for them. The employer knows that, and if the employer is having difficulty trying to get that individual to work the available hours, then they should notify MDS of that.
All right, thank you, sir. All right, next, we have a team member who is supposed to be working full-time, 32-hour week schedule. That was accepted on her return to work notice. However, she has stated she has no childcare and can only work 13 hours this week between Thursday and Sunday. However, she is now posting on social media today from the beach in Florida on a day that she should have been working. Does this constitute unemployment fraud? And can we have that discussion with her? What ramifications does this blatant behavior have for team members?
Let me start by addressing the issue about does it constitute fraud. It may not constitute fraud on the basis that the person is not filing unemployment benefits. If the person's behaviors, because they're at the beach and they're avoiding work and they are filing unemployment benefits, then it could constitute a refusal of work that may not result in unemployment fraud. Unemployment fraud deals with failing to report earnings, individual who gives false or misleading information for the purpose of increasing his or her receipt of unemployment benefits. Using somebody else's identity to file a claim could constitute fraud, or failing to report a certain amount of wages while he or she is working. I think it's more in line with a refusal of work when they have 32 hours available for them and they refuse to work those hours. Shameful that they're on the beach somewhere trying to milk the system or take advantage of the employer. The employer should confront the individual as it would be anybody else who they have as in their employee, and ask them, about their availability or about their whereabouts. Because if they are providing information to the employer that they are not able to work for childcare reasons, and then the employer has information to show that that was not the reason, then the employer certainly has a right to ask them about that and make a determination whether or not they would see that as a reprimandable offense or incident. And if it's a progressive policy, it may result in suspension or termination.
Thank you.
Yes, sir.
Right, next question. Are any of the appeal processes in place? I have employees that have quit with no notice that I have appealed. I am now getting order of dismissal on these. Does that mean the employee is receiving unemployment payments?
The appeal processes are in place. If an employee quits his or her job and files for unemployment benefits, then an investigation is conducted, and it may determine that the person had good cause for leaving. If that's the case, then the employer will receive a notification that the person has filed for benefits, and his or her, the employer's account will be or may not be charged. As you know, Jimmy, in a separation for quitting, charges is always addressed. However, in a quit, it could be a situation where the individual who filed is eligible and it's a non-charge on the employer. However, as it deals with appeals, a dismissal from an appeal would be that the person who filed the appeal could have withdrawn their appeal, or the appeals department would determine that the appeal was not necessary because the person wasn't eligible for benefits, or the person changed his or her mind. In those cases, the employer is notified that either the appeal was withdrawn or dismissed. It could be, and I reached out to the appeals chief, and he was not aware of any specific instances or patterns, should I say, but it could be in a dismissal that it's determined by the agency that a person does not qualify for benefits and under the regular unemployment benefit program, and therefore is eligible for pandemic unemployment assistance benefits, which would not be chargeable to the employer and would not have an impact on the employer's account. And that person could, as a result, the appeals department could, as a result, dismiss the appeal after talking to the parties and say it's going to result in a denial of benefits under the unemployment guidance from the Department of Labor, that if the agency determines that a person is not eligible for regular benefits, they could proceed to the pandemic unemployment assistance benefits, which does not end up as a charge against the employer, but as a pattern. The appeals chief was not aware of dismissals going out on a regular basis.
So in this particular case, we can't directly answer because we don't know the specifics. So if that employer wanted to send us, say, the name of the individual and last four of social, we could look it up and talk one-on-one with that employer
Absolutely.
to explain specifically what
Absolutely.
occurred. Okay, so yeah, we can do that if need be.
Yeah.
Okay, we can move to the next. Okay. Next question. When someone files for unemployment, what steps are in place to see if they are deemed to be eligible or non-eligible? And also, what is the turnaround time on these?
When someone files for benefits, the party is issued, both the employer and the individual filing for benefits is issued information. As far as employer notification, they are sent a notice informing them that a claim has been filed, and a request of information is issued to them as well. On the notice issued to the employer, the reason that the claimant indicated that he or she was filing or separated is stated on that form. And the employer is asked to verify that information. If it's a lack of work, there's no need for them to respond. But if it is something other than a lack of work, the employer is asked to notify the agency of the reason for separation. In some cases, it is not a lack of work, and we expect the employer to respond to us as soon as possible to notify us of that. It is extremely important at this stage under the provisions of the CARES Act. Normally, the employer is given notice saying that they have 10 days to respond. And in some cases, employers are very busy and don't have the staff to respond to those requests immediately. And sometimes they respond on the 10th day. That's good in some cases. However, under the CARES Act provisions, the 1 week waiting period for claims filed against Mississippi have been waived. Therefore, a person could file a claim indicating that it was a lack of work, and in fact, it was not a lack of work, and within that 10-day period, actually get paid unemployment benefits. So it's very important that the employer respond timely to those notices. If it is a lack of work, there's really no need to respond, but if it's not a lack of work, we need to know that as soon as possible. Again, one of the ways to do that is to report that information to us on the Restart Mississippi or Restart MS function, and we'll get to that later on. But the turnaround time is usually 10 to 14 days at this point in time. If it's a separation issue, those are under investigations, and they're taking more than 14 days.
All right. Next is we have a team member that says they have been exposed to a family member with COVID-19. They say they are self-quarantining for 14 days, but provide no documentation regarding exposure, follow up with the healthcare provider, or that they have even been tested. Some refuse to be tested. Keep in mind as well that a 14-day quarantine is no longer the CDC guideline. We also find out from other team members that they plan to file for unemployment while they are out. So the question is, how do we handle this situation? Are we supposed to take the team member's word about exposure with no documentation? Do they qualify for unemployment? if they are out for supposed COVID-19, even though we aren't subject to Families First and have a time off policy?
How do you handle the situation? I think, first of all, respecting the person's privacy, that they may have a medical issue that needs to be considered as personal. However, as an employer, you have the right and the responsibility to make sure that you provide a safe working environment for your employees and the company. You should ask the person for documentation of their diagnosis that they are sick. If they can provide a medical excuse showing that they are not able to work for that reason or for any reason, then whatever your policy would be regarding a person who's out for medical reasons, then I think you stick to the policy. If that person refuses to provide some documentation, some medical documentation, and you have a policy that requires them to do that, you should follow the policy. There is, to my knowledge, no provisions under the CARE Act that would preclude the employer from following that policy regarding attendance issues for health reasons. So if you ask for the information, the person refuses to provide it, then I would document that, and I think very simply tell them if they don't provide it within a certain time period, then they're subject to some disciplinary action up into including termination or leave without pay. So if that's your policy, then I would say follow the policy.
Okay. All right, next. When is the work requirement going to be reinstated? And I believe that's probably the seeking work or looking for work requirement. We are getting few applications because no one wants to come to work until August 1st when the $600 federal benefits run out. We can't replace these team members when no one will apply for jobs since they're making more at home on unemployment.
The requirement for seeking work is a part of the waiver, is a part of the current executive order. That executive order ends on July the 25th of 2020. And at that time, the requirement to return to work should be in place, except the executive order extends that. But the federal money for the $600 also ends in Mississippi the week of July the 25th. So they are sort of coincide hand in hand. So at this point, more than likely, individual will be required to resume looking for work.
All right. All right, so next question. Is MDS coming out with anything regarding unemployment fraud that we can post and share with our team members? For example, a publication.
Yes, currently there is information on the MDS webpage about the fraud, both for the employer community and for the individuals who may know of individuals who are filing and committing fraud. The communications department in MDS, and along with our internal audit department, are working on reviving a current publication and be notifying the employer community of that. It's my hope that we can send it out electronically to those that we have their emails for, and for others, we'll be mailing it out to them within the next week or so.
So you bring that up, Timothy, about the employers we have emails. So if employer has not come into the unemployment reemploy system, they can log in, and either if they don't have a login, create a login. But if they do have a login, then go in and update their email it can make communications much quicker, as we found in this pandemic, if we do have a valid email address.
Absolutely. We encourage that, Jimmy. We started the campaign about a year and a half ago to try to get employers online with correspondence with their emails. And I would encourage any employer that doesn't use that functionality to do so and provide their email. And if they don't know how to do that, they can contact my office and we'll be able to provide them that information.
Okay, thank you. Okay, next question. We have heard discussions that MDS is developing a new function that will allow employers to review their records and see who is filing a claim against their account. If an employee has been terminated, refused work, or was still working full-time, how could the employer report the claimant's status?
Regarding the new functions, there are ways to do that currently, and you're right, Jimmy. We have spent better part of the last 6 to 8 weeks working on initiatives, and in the last 2 weeks or so, we've come up with what we refer to as Restart MS, Restart Mississippi, as one of the governor's initiatives to try to stimulate reemployment activities in the economy. And I think on the screen, it's showing a screenshot of the agency's webpage. And at the very top, there are 3 headers. One is for COVID-19 response. Below that is individual file unemployment claim or weekly certification. And then the third header there is employers to restart MS, which is clicking there would give them an opportunity to log into their account or request a new login certification so they can report to us refusals of work, individual who may be working 32 hours or less and avoiding coming in. They can report fraudulent claims or identity theft claims. So that would be the place to report that information. That is up and available now. Individuals, employers can use that as we speak, and we certainly encourage them to do that. It's much better, in my opinion, than sending in a fax or calling the contact center or the benefits department. That information can be uploaded very easily. And if I'm not sure, Jimmy, if you want to go into some of the features of that right now, is that another question?
No, sir, it's not, but I can speak on it briefly if you'd like me to.
Okay.
You want me to talk, or you?
It doesn't matter. We could discuss it.
Okay.
I don't want to switch roles here, but if you have some questions, and if I don't give enough details, you're certainly at liberty to talk on it.
Okay. Well, the one thing to make sure I think need to cover is how to log in. That the employer could use the reemploy or the letters that are being generated now. If you'll cover that for them.
Very good. We are generating notices to the employers, the ones that we have addresses for, maybe new employers that just registered in recent weeks may not be in that mail out, but for existing employers who have an existing account, we are sending out through U.S. Postal Service mail, giving information about the summary of this program, the benefits of the program, and how to utilize the program. Individuals who've already been identified within your business that have access to the Reemploy MS system can log into this portal and with their username and password and beginning using the information and providing us information immediately. Individuals who may not be familiar with the Reemploy portal can create their own username and password and access code that they can use to log into the system and provide information and check and see whether or not individuals who are currently employed and maybe individuals who are former employees who may still be on that employer's account are currently filing for benefits. And they are features that would give, we hope to be more self-service rather than keying in information in a spreadsheet and uploading the information. All those workers will be listed along with their name and last 4 digits of their social security number. And then there'll be some functionality to click on whether or not it's a rehire or a new hire or refuse to work or a fraudulent claim or identity theft claim. And you can select all the employees. And then from there, say for instance, there's been a mass layoff and individuals did not return back to work. You can deselect the ones who did and keep those who did not return back to work selected, and then give us the reason, such as refusal of work or failed to return to work, and the date that they failed to return and when work was available for them, and hit submit. And that would, at one submission, notify MDS that those individuals have refused to return back to work on a certain date, and that would create an issue for us to investigate, contact that individual, and notify them of that the employer has notified the agency that they refused to work and do an investigation. And once the investigation proves that they refuse to work, they may be denied benefits. Another functionality, without going into a demo, but another functionality would be regarding not separated. Individual who has not been separated, who's still employed there, it would be an indication that somebody has filed a fraudulent claim or filed a claim using their identity, or that they themselves, unfortunately, may have filed a claim, and now the employer can see that quite readily and address that to us, so we can address it and take the appropriate action. I think one of the better features, which is something new for me, is when employers cannot reach somebody or cannot contact somebody, they can select that option. And if they are not able to reach that employee, then we will notify that employee, if they're filing for benefits, that the employer is trying to reach them. The WIN Job Center will be assisting us in that effort to notify those individuals, to contact the employer, and if they fail to contact the employer within the time periods prescribed, that individual is subject to be denied benefits up into 12 weeks or 3 months. And I don't know, you want me to go further, Jimmy?
Oh, no, I think the letter is going to describe most of this.
Sure.
But one thing I want to make sure, to create a new user for the system, that letter is going to contain a unique authorization code that they will have to utilize to create that new user.
Yeah, that's one of the safety features for integrity. We don't want just anybody to be able to log into the system and be able to get information to employers' records, but that is correct.
Okay. And the system shows individuals that have filed for unemployment since the pandemic began.
Yes.
And then also if they're currently filing weeks trying to obtain benefits each week.
Your current filers, yes,
Yeah.
sir.
Okay. Next question. When we get the notice to employer of claim filed, the quick access system does not allow you to enter a not unemployed or still working separation reason. If we have an employee who has never been separated, this would allow us to notify MDS much quicker. Does this functionality already exist? And if not, could this be implemented?
Yes, I think that's pretty much similar to the previous questions. We now have this feature of Restart MS, Restart Mississippi, where the employer can log into our system and report that information to us instantly, and we'll be able to take immediate action. They have some options now to see the individuals who are filing, individuals who are filing the weekly certifications, individuals who have filed, as you said previously, from COVID-19 inception, and report that information to us online through the Restart MS function.
And Timothy, just to clarify on the Restart, that will update nightly. So each night, if individual files a claim today, an employer could see that tomorrow.
Yes, yes. If they're like me, they're probably up pretty late at night, so early in the morning should be there.
Okay, good deal. Next question, if an employer is working 5 days and an employee misses a day, how are we to report the days missed? Do we use the refusal of work on the website?
My suggestion would be to use the Restart Mississippi function. You can use the refusal of work on the website. However, at some point that will probably be retired, and we hope to promote and use the Restart Mississippi initiative on a full-time basis. So you can go there, select that individual, and inform us of what action that he or she is not taking or refusing to work or not working the days or the schedule available.
So again, in this example, if the individual or employer has a 5-day work week, that employee, if the employer advises through Restart that they've returned full-time, that individual should not be eligible for unemployment if he just periodically calls out a day or two here and there, right? Is that correct, Mr.?
It should be that the individual, I think every situation should be looked at individually. If the person is exhibiting a pattern where he or she is refusing work or calling out, then if the employee has a policy to address that, ask the person for reason. And if it's a medical reason, asking for medical documentation. If it's not considered good cause by the employee's policy, it may very well be considered to be a refusal of work, and a refusal of available work for a person who is employed full-time could result in a denial of benefits and a disqualification for weeks.
Thank you.
Thank you so much to Jackie, Timothy, and Jimmy for providing this valuable information today. Thank you for all of those who submitted questions ahead of the webinar. We hope that all of you found this really helpful. If you have additional questions that were not covered during the webinar today, please email those questions to Lauren Shell, who will direct your questions to the appropriate person for a follow-up. We truly appreciate all attendees for joining us today for the Madison County HR Roundtable. With that, we will conclude this meeting. Hope you and your family stay well during this time.